Upannyas lecturer, PS Vasudha College, Kakinada, affiliated to RKV Nannaya University, Rajmahendravaram. Teaching CPC subject and topic is the execution proceedings. Actually, the court can frame the issues and it can deliver the judgment. And in accordance with the judgment, the decree can be framed. Actually, the procedure to the passing of decree is actually plain, the written statement, summons, the hearing of the case at the first instance, and framing of issues, arguments, production of evidence, arguments, judgment, decree, and again the execution proceedings. Actually, the plaintiff is nothing but the written contention of the plaintiff. The plaintiff, he can give his written contention about the cause of action. Actually, what the transaction is held and what the dispute is arose between the plaintiff and the defendant. All the contention is given in form of by the plaintiff. And the court can give the time to the defendant to file the written statement. The written statement, it is nothing but the written contention of the defendant. Whether he accepts the cause of action or denies the cause of action. Or whether if he accepts the cause of action, whether he denies the claim. All these can be given in the written statement. After reading of this written statement and the plaint, the court can frame the issues and it can consider the matter as a dispute and it can hear the case by calling of the parties before the court of law. It can examine the parties and it can dispose the case at the first hearing if it is possible. Otherwise, it can frame the issue and again it can give the time for the plaintiff and the defendant to produce their evidences and it can give the time to the arguments, and on the basis of the evidence whatever produced before it and on the basis of the arguments it can deliver the judgment. Actually, the judgment is delivered in the open court, and if it once delivered, it means it is not altered or not added except for the clerical or the numerical mistakes. Actually, if it is pronounced or it is delivered, it means it is operative. And again, on the basis or in accordance with the judgment, the decree can be passed to the party. Actually, the decree is nothing but it is a formal expression of the court in accordance with the judgment. The decree can be passed means the contents of the it means it is the final. The decree can be passed, it means it is the final and it is conclusive to the court which is passed. Actually, in framing of the issues, the main element is the jurisdiction of the court. Actually, if it is a competent court jurisdiction and it is passed, it means an effective and operative decree. Actually, decrees are classified into the preliminary decree, the final decree, partly preliminary and partly final. Actually, preliminary decree means it can be passed by the competent court jurisdiction preliminarily, and if it is partly preliminary and if it is partly final means the partly preliminary final it can be operative and preliminary it can be challenged in another court jurisdiction in form of appeal. Actually, the main contents of the decree are it shall agree with the judgment. This is the main basic point and main basic element. And it shall contain the number of the suit, example, OS number, etc. The name and description of the parties and the claim particulars. The claim specification, it means what the relief is granted and the amount of cost incurred in the suit, and decree shall signed by the judge. If the judge vacated the office, who gave the judgment? If it is not signed, it may be signed by his successor. Decree should be self-contained and capable of execution. Decree is the mouthpiece of the suit. Actually, decree can be passed by the competent court jurisdiction in the following cases: the suit for recovery of the immovable properties, suit for delivery of movable property, suit for possession of immovable property and mean profits, preemption suits, and the administration suits, dissolution of partnership, suit for accounts between the principal and agent, and partition suits, and again the suits for the family issues. Actually, the court can exercise the inherent power powers according to section 151 of CPC. It shall be exercised by the court of law for the ends of justice or to prevent abuse the process of court. It does not formulate a new doctrine but merely forbids legislative recognition of well-established principle that every court has inherent powers to act and do real and substantial justice. CPC is not exhaustive. There will be always cases and circumstances which are not covered by the express provisions of the code. Inherent powers are discretionary and there are limitations. It can be exercised only when there is no other remedy or alternative remedy. The power has to be exercised in order to advance the case of justice and not to allow the justice to be defeated. Actually, what are the inherent powers and when the court can exercise or when the court can enjoy the inherent powers? To consolidate suits and appeals, to stay the cost of suits on ground of convenience, to ascertain the proper parties before it, and to inquire whether the plaintiff is sufficient to sue as an adult. Entertain the application of a third person to be made a party, restore a suit, dismissed for default, and next to transfer the suits and punishments for the contempt of courts and divide the question of jurisdiction, etc. In these situations or in these circumstances, the court can enjoy the inherent powers and no appeal lies from the order passed by the court in the exercise of inherent jurisdiction. Inherent powers are not exercised in case of to restore suit dismissal for default of non-payment of court fee and to compel the parties to submit to medical examination or to blood test or to consider or review an order or to set aside an ex parte decree. What ex parte decree is? Actually, if the party is not attended before the court of law by the requirement of the court of law to attend before it, the court can decide the matter in the absence of the party that it is treated as the ex parte decree. And actually, the court has no inherent power to set aside the ex parte decree. Actually, after passing of the decree, the execution proceedings can be started. Actually, the execution, it is nothing but executing the judgment or order given by the competent court of law. It is a process to enable the judgment. There are two parties. One is the judgment debtor and another one is the decree holder. The execution proceeding, it is to recover the fruits of the judgment by the creditor. For the execution process, the decree holder can apply. If the decree is passed in favor of more persons, any one of the joint holders may apply for execution proceedings. The execution proceedings are started by an application. And the application for execution should be in writing, signed and verified by the applicant or by the persons who prove to the satisfaction of the court. And the execution notice, the application, it shall contain the particulars, the number of the case, the name of the parties, the date of the decree, and any appeal has been preferred, and payment of any alter any adjustment between the parties have been made, and the previous application have been made for the execution. Amount of costs are awarded. The mode in which the assistance of court is required. Actually, either in form of delivery of property or attachment of property or arrest and detention, appointment of a receiver or nature of relief granted. These particulars can be required in the application. No notice is required to the party when against execution is applied except application is made more than 2 years after the date of decree. Interest of decree holder is transferred by assignment. Execution is applied for against the legal representatives of judgment debtor. Application is made for execution of a decree filed under section 44 of foreign judgment. Actually, the execution of the court should not go behind decree. If a decree is passed without jurisdiction, decree is nullity and decree is ambiguous. The execution proceedings may be transferred from one court to another on the application by the decree holder. If the judgment debtor actually and voluntarily resides, carries business within the jurisdiction of other court, the judgment debtor's property is not sufficiently satisfied within the jurisdiction of the court which passed the decree. Decree directs the sale or delivery of immovable properties outside the jurisdiction of the court which passed the decree. The court passing it considers that it should be executed by the other court. Actually, the execution proceedings can be started within the 2 years of the passing of the decree. After 2 years, if the execution proceedings are started, the application must be filed by the parties compulsory. Actually, the execution, it must be for either the delivery of property or attachment of property, arrest or detention of the parties, appointment of the receiver, or the nature of the relief granted. Actually, the court can dispose the case and it is the final stage of the case whatever taken before the court of law for the final judgment. With the execution proceedings, the case may be summed up.